Good day. It's the 25th of May 2022 and you're very welcome back. This is video number 45J, Wind Farms Court of Justice of the EU Ruling 2419. So we'll just get through it here because this is important for anyone facing wind farms. Now, this is the Real True Education channel, not fake news. Real True Education, not fake news. I don't have my banner just here at this venue. Now, to get the ruling, and I have to say in the very first one I made, that's 45J, it was 45H. I referred to it as 2519, and that was a big mistake. This is the ruling you're looking for, right? This is the ruling, okay? 2020, see it there? 2419. That means ruling of the court, the Grand Chamber of the European Court of Justice, number 24 of 2019. 24 of 2019. Now, the SEA directive, the EIA directive, and a number of other directives carry with it a cost protection order under Section 50B. That's Section 50B of the Planning and Development Act 2000 as inserted by Section 21 of the Planning and Development Miscellaneous Provisions Act 2011. So that means that you are protected against the costs of the other party, subject to certain conditions. You can't bring up something which is well settled, but this is not well settled. If you're going to ask the court, the High Court, to change a ruling of an earlier court, the earlier court is not binding. You might have to go further than that. So, but you can't obviously shout and roar at the judge or the other parties. You have to behave civilly. No problem. It's no problem at all. I availed of it 3 times there. But just be aware, it doesn't always apply to non-EIA stuff or non-European directives. So land law, for example, who owns a right of land, a piece of land or something, might not be covered. It just depends. We're not going to that. Now, the next thing about it is that law is there. That ruling is there, folks. Some people may tell you it doesn't matter. It definitely does matter. Now, I have to say at this juncture, I am not your lawyer, I am not your barrister, and I cannot be held accountable. I will not accept responsibility for the use of the information I give. This video is about putting you in the right direction, and how it's pleaded and how it turns out is all played for, and you can lose. And in a rare case, you could be ordered to pay costs. In the North East Pylon Pressure Group case against the pylons, they had an awful lot of land law in there, and I went to the European Court, and I think they got their costs, or they were saved from their costs. But just be aware that nothing is certain. Nothing is certain in a court case, but that doesn't mean you don't go it. And if you had the wind turbines that I have beside me, beside you, you would take a risk. I don't think there's too much risk, but I'm just saying I'm not taking responsibility, and I can't be held accountable for the advice I give. I'm not a lawyer, and I'm not employed by you, and I'm not your client. So now the next thing then is your group. When you set up a group, what to look for in it. So identify weak links. You don't want weak people at the top. You want people who have a little bit of nerve and a little bit of bottle there. You don't want them at the top, in important positions, and it's something to watch out for. Now, watch for members of your group who are involved in political parties and are involved in politics, who are only there to try and get a quick vote or something off you. Now, you cannot say that those involved in politics are all wrong and are all against us. I mean, there's a Fine Gael councillor, Andy Duncan, in Mullingar. Great fisherman he is, and my did he work on that council, and what great work he's done. He's done great work and got the wind turbines confined to certain areas, and there have already been applications rejected by the planning authorities because of laws and rules he brought in. So you can't just paint everyone with the one brush, but then you get other people who are really tied into political parties and who will put the party before you, and you want to watch them on a committee. I'd have Andy Duncan on a committee any day, but I wouldn't have some of the boys on a committee. So you just have to use a bit of common sense. Now, The other thing is planning advisors, and there are a good few planning advisors around who they try and help you all the way, and then they get you a firm of lawyers and all that type of thing, and they get their cut and all that. But you want to watch if you're dealing with a planning advisor. Do they agree with this SCA? Up to now, the National Renewable Energy Action Plan has never been challenged, and that says something about planning advisors. Why didn't they challenge this on the SCA Article 3.2 long ago? And one of the reasons could be that if we bring down the whole wind energy program, I have to come up close to this to be heard. If we bring down the whole wind energy program, even for a couple of years, that is a serious hole in their income, because they're relying on an application for a wind farm every 6 months to keep it going, and they hope to get their cut. So it's not in the interest of practitioners and consultants to block the whole thing, to end it all. Just be aware of that. And you need to look at the past history of consultants and people who act as consultants and inquire a bit about them before you apply them on your case. Some of them will be great on the Habitats Directive. Some of them will be great on the EIA Directive, the Local Environmental Impact Assessment Directive. But if they haven't gone this route or haven't considered the SCA, you have to wonder, is there heart in it? So you don't want somebody who, by winning for you, will lose their livelihood partly or lose part of it. Just bear it in mind. Just bear it in mind. Now, so the protective costs order means that your own costs you have to pay your own costs of your legal team. But if you win your case, you could get your legal team's cost as well. In my case, I won one judicial review. The judge didn't side with me and two others, but I had to pay no cost. I was out my own costs, but I wasn't out the cost of the other party. So if you win, you could get your costs. And if you have a legal team and you win, well, you have to get all the costs. So just be aware of that. With this ruling, I don't really see how you can lose. Now remember too that lawyers must feed their families. We're not expecting them to work for nothing. In fact, if I saw a good barrister, a good lawyer, I would wish him well, make him a rich man. Now I employ solicitors in various other aspects of my life, and some of them are very good. I wouldn't have them if they weren't good. But remember, the solicitor on the high street or that, they may not be trained for this. They're not into this, and they don't understand this, and you can't really blame them like that. So you cannot just select, oh, I always went to Michael, your man down the road, and he'll be all right this time. That won't be. They don't know where to pick the right barristers. You, the group, must pick them after all the information you can gather. So yeah, selection of a solicitor and barristers is the most important thing. Now, actually, if you select the barrister, you get the right barrister, the solicitor will come. He'll know somebody that will do it for him. Now, so what you need in lawyers is, and this is something I feel very strongly about now. We've looked very hard to get them. You need ones that will work with you. You don't want ones that will work for you, or that will work against you. With you, for you, or against you. I prefer the one that will work with you and sit down and discuss the case. A lot of them don't like it. A lot of them are a bit snobbish and a bit protective. And you can get ones that will sit down, and because this is all new law, this is all new ground, 2 heads, 3 heads is better than one. And certainly in our way, we discuss everything among ourselves and try and come up with a consensus. Now, some are very secretive. I don't know. I wouldn't trust them. They're not good. And who are they? Where do they come from? What's their background? I can't say. Now, I won't mention specific lawyers. I know there's a famous one in Cork, and seems to be quite good. Had a good bit of success. And I met him, and he's good. He's a good lad. And there's a couple of other groups, known barrister groups. I won't just name them here. Now, I was looking for one myself and my friend Pat Swords. We are European Platform Against Wind Farm members, and we've been looking for a good barrister. And recently, in the last year, we think we found one by pure accident. And you'd think it was fate. You'd think it was just good luck. Actually, it was just a kind of a particular mention of something. I'll not go into it here. This man has worked with Pat Swords demanding the paperwork for the what do you call it, the COVID-19 lockdown, and they didn't give it to him, and eventually the whole lockdowns were called off, and then his case kind of fell. Didn't want to give him the cost, but this lawyer, this barrister, got his costs because he pleaded that he had to fight the case to get it that far, and the European Court of Justice ruled that he was entitled to his costs, and those costs went to something about €700-800, not that much, but he's already won in there. So we have our man as well. Now, we not mention any names. We have to be fair to everyone who makes a decent effort. Now, how do you contact me? One man there wants to know how to contact me. I can't give out my details. Once I became known that I was campaigning in wind farms, I was inundated with requests from Britain and London to know would I invest in wind farms. They just get all screwed up, all mixed up over this. Also, my phone was tapped, and my phone company arranged, or somebody arranged it. I was getting nuisance calls for over 5 years, ringing every 2 hours, and my home number was got nuisance calls, and is still getting them. Anything up to maybe 8,000 to 9,000 calls in the morning, usually, or in the daytime, which is a nuisance. Like, people answering the phone. Got to the stage we couldn't answer our landline. I have no doubt that's partly as a result of these people trying to get one up on me or cause a bit of hassle. So I won't give you out my details. But this man is a member of our association, John Joe Dooley. He was on here. He's a retired engineer, and he's our agent for contact. And I'm going to give you his email address. This is all you'll get now on this. So it's very important to get it right. Here's his email address, and it's John J. Now look at it here. J. Dot. Don't forget that blue dot. I made a blue dot there. Dooley9 at iCloud.com. J.Dooley9 at iCloud.com. Now, it's all lowercase, folks. It's all lowercase. Now, I've done it out here again, and I'll leave it for a while. We'll see it again. J. Dot, that's the big thing. Dooley, Dooley 9 at iCloud.com. At iCloud.com. Right? That's it. All lowercase. Now, in the case of a barrister, it's nice to have one that does their own writing, that's computer efficient and can draw up their own documents. Because what a lot of barristers do is to give an advice and to send it down to the solicitor, and the solicitor has to do up all the documents. It doesn't really work well with this kind of law. It doesn't work well. I know one case which went kind of bottom up because of it. They need to do their own bit of work. So the big firms that I've mentioned there, they do it. But it's just something, we have no problem with our people anyway. So that's very interesting there, that do their own writing up. And we'll keep control of it. Now, there are big firms there. I have to be fair to everyone. I mean, these plead on behalf of Bord Pleanála, Mason Hayes and Kern, Philip Lee. I have been opponents of these, and A&L Goodbody. I'm only telling you about them. I don't have a clue whether they take on a case. Remember, the barrister you pick this time might be on the opposite side the next time. You know, that is the case with lawyers. So I'm just putting it in there to be fair to everybody, because on a personal basis, when you go into the court, even as a lay litigant, sometimes they can be very awkward if they want to do, but they don't. They just behave in an ordinary professional way, and I have no complaint about them. Maybe about getting a sitting, or maybe a difficult time, or adjournment or something. I don't find there's a kind of an etiquette among them, which is refreshing, I have to say. So I'm just putting them in there to let you know I'm not discounting anybody. However, we need to be very careful. We're taking on the government here. Now, one of the big problems with barristers is that they'll change their plea as they call it on the steps of the court. They're all with you, and all of a sudden, the morning of the court, they tell you there's some problem, and you haven't time to look it up. They tell you there's some problem. You don't want this. This needs to be brought all the way. You only get one bite of the cherry. Now, if they misbehave, you can dismiss them. It has to be said. Now, the ground will be the 2006 Wind Energy Guidelines. 2006 wind energy guidelines. Now, secondly, there is no SEA on the National Renewable Energy Action Plan of 2010, and the 2006 Wind Energy Guidelines have not been assessed under the Article 3.2, and this has now been ruled in the European Court of Justice. So you have it all handed to you. Please read the black writing at the bottom of the judgment if you don't have time to read it all. Now, my friend Pat Swords, who's a great campaigner, he would like the fact that there's no SEA on the onshore wind aspect of the National Renewable Energy Action Plan and the other aspects of it, including solar and all that sort of stuff. He'd like the whole National Renewable Action Plan to be challenged and brought to the European Court of Justice. He's worked so hard to try and get that done. Oh, you want to see the effort that was put in, and it still frustrated us. But I wouldn't blame your legal team for saying, we'll not go that far. That is not a sign of weakness. They might say go in on the 2006 wind energy guidelines. Look, it's the easiest, the safest, it's everything else. But you could put the first ground, the National Renewable Energy Action Plan, not being assessed, and then the second ground being the wind energy guidelines that form the basis of the environmental impact assessment. So what you're saying with the second one is the environmental impact assessment is invalid, because it cites the wind energy guidelines as 2006 as justification for the placing of the turbines and all that. Okay, so that would be the way you'd be going. Now they'll know all about that. Anyway, I think you get my drift so far. Now you're taking on the government, but I wouldn't let that frighten you. It just means they'll fight a bit harder. Now, you must see each court as a step. You have the council or the Bord Pleanála, you have Bord Pleanála, you have the judicial review to the High Court, and they can appoint any judge. When it comes to dealing with Sean Quinn, they were able to appoint a very proficient Justice Peter Kelly. There was no chances taken there. But with the ordinary Joe Soap and the lay litigant, they're able to appoint a judge that never dealt with any of this. I mean, they can do what they like. So you have to take into account that anything can happen. So the High Court is really only a step to the Supreme Court. So that's the court. You don't go through the Court of Appeal. It's the Supreme Court is the next one. And you have to get leave of the judge to let you go to the Supreme Court. But if he refuses it, you can go to the Supreme Court, and you can, on the grounds that European law is being breached. A lot of good lawyers will know that. Now, there was a recent challenge by, I think there were members of the Green Party, of all people, to a trade agreement between Ireland and Canada, where it was agreed to set up a court to deal with issues of contract and all that sort of stuff. And it was challenged in the High Court because there is only one lawmaking body in Ireland, and that's the Supreme Court. If it's European law, it's the Court of Justice of the EU. Now, this law is European law, but the law on the trade between Canada and Ireland is Irish law only, and that looks to be going to win. Now, the lady judge threw it out. She said, "I don't see any basis to this." Now, it's been challenged to the Supreme Court, and it was in the paper that it could go in favour of the challengers, because how can you have a body sitting somewhere who has bigger powers on contracts and all that than the Supreme Court in Ireland? If I'm a company here making sweet cakes, I shouldn't be forced to go outside of my own legal system and my own country, and that's been challenged at the moment. And that's a classic example of a case that was rejected in the High Court, and it's gone into the Supreme Court, and it'll end. The Supreme Court has the ultimate authority there. So just see that there now. So I'm just telling you, you need to look at each one as the stage. You have to go through these courts, but in the end of the day, you're trying to get to the European Court of Justice, and I personally cannot see how you can be stopped. Now, so that's the hierarchy there. The High Court can be any judge. It goes to the Supreme Court, and it goes to the Court of Justice of the EU. Normally, the Court of Justice will say it's for the National Court to decide certain facts, and then when they decide that, this is the law. Now, no work can commence on your wind farm once this is pending, so you have a respite. Now, the other parties is almost certainly going to plead that you should have challenged these guidelines in 2006 when they were made. Well, unfortunately for them, unfortunately for us, the Court of Justice in this judgment has ruled that it's up to Ireland to have the proper procedures in place, and they can't expect the citizen who had no reason to challenge it in 2006 to turn around now and to challenge it now, or to challenge it back then. I mean, they couldn't be expected in 2006 to challenge this when they didn't even know they were going to be affected by it. So the European Court threw that out the window. You could still get a court in Ireland that would try to plead that, but if it goes to an appeal to the European Court of Justice, it looks to me like it's a no-brainer. They won't get away with that much as they would love to. Now, Belgium and Holland have already set the precedent. I've said that in the earlier videos. I've told you about the earlier video, 45H having a mistake with the number of the judgment is 2419. Another good thing about this, it'll create uncertainty in the markets. I mean, if this is going on, I mean, who's going to invest in windmills when the whole lot can be struck down, the whole lot can be found to be illegal? The government do not want this, folks. They do not want this. They can only make laws for the future. They can only make laws. So if they are forced to make laws, they can only make them for the future. What's going to happen then to the past? All of the wind turbines built are illegal. We'll not go into that. You're not worried about that. Your worry is this is coming down the road and you want to stop it. And this is one of the big grounds that you'll stop it on. Now, the new guidelines, if they bring out new guidelines, they must be subject to the new SCA process. There must be public participation. There must be the right to take judicial reviews, and we'll give them a run for that. And it's their worry. That's their worry, how they deal with it. We don't have to worry about it. It's their mess. They created it. Now, that's their mess. So let them do what they like. I saw one reporter with the Dutch situation where they said that's only a matter of the local authority doing it. Has to comply with the SCA directive, folks. And that means going the full Monty, the whole hog. Now that email address again, jdooley, JDOOLEY 9@icloud.com. He will pass on any messages. I'll have it here again, and you will hear back. Don't be afraid to send another message. There could be mistakes. As I say, our barrister we now have, he almost didn't get to know the doors at all. It was a pure stroke of luck. Maybe it was the man above, maybe helping us out. But anyway, that's it. Now I hope you're able to hear me there. I hope you can get that and give me a thumbs up or a thumbs down. It's high time we tackle these on the real law. And the other point about it is there could be groups there. Many groups have money and they collect money, and there could be groups there who have somebody rich in their community. And generally speaking, these people won't get on to me. I tried one of them up in Donegal, he wouldn't respond. And we have a few, but we could hit it lucky. And the way to deal with that then is head in on the full whack. The pylons, the whole lot, the National Renewable Energy Action Plan. But for now, anyway, I've explained to you, there's no proper SCA, there's no SCA at all for onshore wind in Ireland. No SEA for onshore wind in Ireland. None at all. Big helicopter going overhead. But there is a sort of an SCA done for the National Renewable Energy Action Plan, but I don't think it'll pass the test. And so with that and the helicopter going overhead, folks, give me a thumbs up and a thumbs down, and we'll see you back for something else on the court case 2419. Bye.